Very much, Craig. Well, earlier this week, the Supreme Court heard arguments on a case that examines free speech in social media. At issue is whether violent rap lyrics that were posted on Facebook are protected by the First Amendment. The case centers around a Pennsylvania man who was sentenced to nearly 4 years in prison for posting lyrics about killing his estranged wife and attacking an FBI agent. Well, his lawyers argued that he was just venting and that the posts were free speech. Paul Harding from Martin Harding and Mazzotti is here now with us in the studio to talk more about what is really a fascinating case. And I guess every one of us who has a Facebook account or a Twitter account, not that I would ever post those kinds of lyrics, but I mean, you have to wonder what is free speech. And that would be my question to you. Why is free speech not coming into play here?
Sure. You know, I mean, it's a cornerstone of our country, of our Constitution, the ability to say what we want to say and not feel that we're going to be in danger by saying that. But one thing that has never been protected by free speech is a true threat. If you truly threaten someone, those words will not be allowed. And quite frankly, what they found here is that this was a true threat and criminal charges were brought. And
I know his argument, the guy involved here, was that this was a song. These were lyrics from a song and that there was no threat.
Well, everyone's got to have a defense, right? You just don't want to walk in and say, you got me.
True.
But in this case, you know, he said, the Beatles have done this, that Eminem, the infamous rapper Eminem, always talked about killing his wife, Kim, and she was going to be at the bottom of a lake. And so he said, look, what I said was similar to this. I didn't really, doesn't follow through on this. I was just sort of venting and kind of saying those words. But the current rule says that if a reasonable person would assume that those words are intent enough that you can be convicted of the crime, and he's saying not so. So the Supreme Court, which takes so few cases, they take just a handful out of the hundreds and hundreds that they're given every year, they want to comment on this, so that part in and of itself is quite interesting.
So what's likely to happen here? What are the implications of this? Again, I'm assuming it gets right back to that, you know, cornerstone free speech issue, where it's going to take us.
You know, we won't know till next summer. The Supreme Court, they just take their time in drafting their opinions. The fact they took it's interesting, but I don't think that they're going to go ahead and just say that you can't have this intent statute. You have to prove that he's actually going to do it before you can bring the charges. If they do, it'll change the way that stalking statutes, harassment statutes are written not only in New York, but around the country.
So, and I was saying to you before we went on that I thought art or the free expression would win out, but you don't necessarily think so.
I don't, simply because that's going to get overridden by the danger that he posed, and so I think that that's where we're going to. Often the free speech will win the day. I don't think it will here, but again, I don't get to sit on the Supreme Court.
That's right, and we've got to wait till summer to find out, but it sure is interesting to talk about now, and we thank you for sharing your thoughts with us on that.